Let's start with docket 375, which has been mentioned several times in court. How material is it in this trial, given that the state says it was a mere memorandum from a junior advocate and it wasn't signed for prosecution because there was no strong evidence against the parties involved?
Thanks very much, Clement. Yeah, so I think that the docket is very important, and it is a very strange thing for two dockets to exist, at least in my experience, in respect of one specific crime. You mention the alleged difficulties or irregularities or omissions in respect of the docket, for example, a signature. Those things would be relevant if it were up to the defense to prove that it hadn't committed the crime. But of course, in our system, we have the presumption of innocence. And so the existence of an additional docket inherently creates doubt. I think that you used the word messy. I think that that is a very apt word in these circumstances. When it gets messy, the defense gets stronger.
Yeah. So Advocate Tifo says the Pretoria High Court can postpone this case to allow for Advocate Mshololo to go through that docket because the court has no power to. What exactly is he challenging? Because a jurisdiction document was signed by the NPA head, Shamila Batohi, moving the case from the Palm Ridge Magistrates Court to Pretoria because of space. And the state says Advocate Tifo didn't object to this transfer.
Yes. Yeah. I mean, it was a very interesting submission, let me say. I mean, let me just take a moment to say that there are two types of jurisdiction. One is a cause of action jurisdiction and another is territorial jurisdiction. It is strange to me to challenge the jurisdiction of a high court because a high court has both territorial and cause of action jurisdiction throughout Gauteng, is the first point. And the second point is the one that you make. It's an acquiescence point. It's, well, the jurisdictional point should have been obvious to you a lot earlier. Why did you not raise the objection? If you fail to raise an objection when it occurs and there's a duty on you to do so, then that can be deadly to a challenge to jurisdiction, even if it did have merit, which I think is dubious with respect.
What did you make of the conduct of Advocate Tifo in court yesterday? Look, we understand that there can be tension in court. There can be disagreements between the judge and the counsel. They can go hard on each other, but within the bounds of respect and decorum of the court. And my understanding is that Advocate Tifo is a member of the Legal Practice Council. What conduct does the Legal Practice Council require of its members? We know in the past they've taken Advocate Dalimpofu to task for his quote-unquote unprofessional conduct.
Sure. I mean, it's not really a nice image, certainly, to see that kind of thing happen in court. It can be uncomfortable, but as you suggest, there is a hurly-burly that occurs in trials, and particularly criminal trials, because, ultimately people's lives are on the line here. And the judge will have been very aware of that when Advocate Tifo was pushing back, if I can call it that. And I think that the judge, if I may say so, handled it well, in that the judge needs to ensure that the judge appears to be impartial throughout the trial. So even if a colleague is pushing a little bit further than the colleague should with the judge is actually protecting the fairness of the process, and that's a good thing to see. As far as Advocate Tifo is concerned, I'm sure that he's protecting the interests of his client. It isn't for me to say whether he is conducting himself unprofessionally, but one doesn't like to see that sort of exchange between a judge and a lawyer in court.
Yeah, and I guess there's a way that these kind of tensions and disagreements can be handled. Advocate Mkhululi Stubbs, thank you so much for making time.
702.
More than a radio station.
Let's walk the talk.